arbitrators. I wanted to share some thoughts on that. And I plan to cover today, really, firstly, just a quick recap on the concepts involved in res judicata. Secondly, how res judicata impacts on the jurisdiction of arbitrators to decide cases. And thirdly, to say something quickly about how res judicata impacts on enforcement proceedings, post-award enforcement proceedings for enforcement of arbitral awards. Let me start by summing up very quickly the key concepts and terminology as a recap. As may be very familiar to you already, in the common law systems, we see res judicata as consisting of two big rules. One, you can't relitigate the same claim, so-called cause of action estoppel. And secondly, you can't relitigate the same issue if that issue has already been decided as a necessary part of deciding an earlier case. And here's a convenient one-sentence summary in an English case of Arnold. Issue estoppel prevents a party in subsequent proceedings from contradicting an issue of fact or law that has already been distinctly raised and finally decided in earlier proceedings between the same parties or their privies. Privies here would be something like an assignee or a successor in title. So there's the core concept of issue estoppel. When is there an issue estoppel? What's the test? There is a clear test, nicely summarized in English law in the case of the Senar number 2. You are issue estopped when there is a decision of a court of competent jurisdiction that's final and conclusive and on the merits between the same parties on the same issue. Foreign judgments, just like domestic judgments, are capable of grounding an issue estoppel. And there is some useful guidance in this case of the good challenger, which is actually appropriate to all judgments, foreign or domestic. They're really valid for both, but may be particularly relevant with foreign judgments. Here are the key points. First, and maybe this is obvious, it's irrelevant whether the court thinks the previous decision was right or wrong. Either way, it's still binding. Secondly, the court should proceed with caution with regard to foreign judgments. Because of the difference between systems, it's not always easy for the forum court to figure out exactly what a foreign court was deciding as a matter of deciding it finally and conclusively on the merits, just because the concepts may be different. Thirdly, to found an issue estoppel, the decision must have been necessary for the result of the previous case. So you can't rely on a sideshow, you can't rely on obiter to found an issue estoppel. Fourthly, and it's a big one, the application of the principles of issue estoppel is subject to an overriding principle that it needs to work justice and not injustice. So there is a residual discretionary element. Now, arbitration awards can also be the basis of res judicata, just as court decisions can. So says the 1960s case of Fidelitas Shipping, and that's all very clear. But just like the requirement that the first decision was from a court of competent jurisdiction, so with arbitration it has to be based on the arbitral tribunal having had jurisdiction to decide the previous case. Christopher Brown, cited on the slide, is just one of many cases which register that point. So far, so easy. So far, so straightforward, you might think. But I have a brain teaser for you, ladies and gentlemen. And I'm genuinely interested in your reactions, your reflections. I found this pretty thorny area with some respectable arguments in both directions. Here's the situation. And the arbitration, where I was one of 3 co-arbitrators, it is to an extent public because there are some public court decisions on aspects of the case, and there's ongoing public court proceedings in one Asian jurisdiction about it. But because I am going to mention some things that are nonetheless still subject to arbitration confidentiality, I have anonymized the facts and anonymized the names and given sort of pseudonyms or code words in which we can refer to the parties and their positions. Biden Inc., as I will call them, successfully sued another entity called, let's call them Trump Co., in international arbitration in London, based on what Biden Inc. alleged was a concluded transaction between them, whereby Trump Co. owed Biden Inc. some money. Trump Co. challenged the jurisdiction of the tribunal, alleging that no transaction had occurred, no contract was concluded, and therefore there was no arbitration clause between the parties. In that first arbitration, Biden Inc. succeeded on jurisdiction and succeeded on its claim. And one twist in the facts, which I'll tell you, is that shortly before the hearing in that first arbitration, Trumpco introduced a new ground of objecting to the tribunal's jurisdiction, namely that the dispute came within a different arbitration clause in a wider agreement. There was a sort of master agreement, you might call it, or an offsetting agreement between the two parties about offsetting debts under different transactions. And so Trumpco said that there was another arbitration clause between them, and that was wide enough to cover the alleged contractual liabilities in this arbitration. And therefore they wanted instead the dispute to be referred to arbitration under a different institution in Asia. The London Tribunal held that Trumpco was too late in raising that argument. They raised it long after they started contesting the merits of the case on other grounds, and therefore under Section 73 of the English Arbitration Act, they were precluded from relying on this late raised ground of challenge. But they also held, in the first arbitration, they also held that it wasn't a good argument anyway. So, Biden Inc. got their award. They applied for it to be converted into a judgment of the English court, and Trumpco did not actually contest those proceedings to register and enforce the first award as a judgment. But then, Trumpco commenced a second arbitration in the Asian jurisdiction based on the clause in that master agreement and seeking relief which would effectively reverse the result of the first arbitration. At which point Biden Inc. cried foul and said, "No second bite at the cherry. Your issue is stopped because the whole question of whether the first tribunal had jurisdiction over this dispute has already been decided in the first arbitration. You shouldn't get a second bite of the cherry to relitigate that point here in this different jurisdiction." But of course Trumpco was saying, well, we never accepted the jurisdiction of the first tribunal, and we shouldn't be deemed to have accepted it now. They said, really, it's rather circular to say that there's an issue estoppel, because to found an issue estoppel, the first decision must have been made with competent jurisdiction. They disputed it, they still don't accept it, so Trumpco's position was, well, you have to prove that the first tribunal had jurisdiction. And in order to do that, you have to prove that there was a contract in the first place, and that means relitigating it all over again. So, and it got pretty complicated in the arbitration, because we as the tribunal had to consider not only whether there was a res judicata from the first arbitration award, but also whether the English court judgment made a difference, created a res judicata, and there was also an order nisi in an Asian court recognizing and enforcing the English court judgment, although that was still subject to a challenge. So, ladies and gentlemen of the jury, that would be a challenge, I think, to any of us to figure out whether the Trumpco's argument on issue estoppel was well-founded or not. Let me just tell you how we came down on it and why. Let's start with the easy points. It clearly was the same parties. It clearly was the same issue, whether a contract was concluded, whether the first tribunal had jurisdiction over the dispute. What about the question whether it was a decision on the merits? Again, here, in our view, not too difficult. That is because it was decided in the Senar number 2, in effect, that a decision on jurisdiction by a previous court or tribunal is a decision on the merits of the jurisdictional issue. So where we talk in res judicata about a decision on the merits, it doesn't have to be a decision on the substance of liability. It can be a decision on matters of jurisdiction, and indeed the Senar number 2 itself was one of those. It was a decision that a particular issue fell within the jurisdiction of the Dutch court, rather than a decision about the underlying merits of the claim. So on the merits, tick. Was the first tribunal's decision final and conclusive in the relevant sense. We concluded that it was final and conclusive, and the crucial consideration was that under the lex arbitrari, the governing law of the arbitration jurisdiction, it was considered as a final and conclusive decision. In the eyes of the lex arbitrari of the first arbitration, which was English law, the tribunal had had the power to rule on their own jurisdiction, and their decision on that had not been set aside by the English courts. And on top of that, I mean, what I've just said is really the ground of the decision, but on top of that, Trumco had not sought to challenge the award for lack of jurisdiction in the supervisory courts, and Trumco, as I mentioned, had been late in raising the particular ground of challenge, and therefore they were precluded under the lex arbitrari from relying on it later. The really crunchy issue in the case is, should one see the decision of the first arbitral tribunal as having been made with competent jurisdiction or not? Or would we need to relitigate the whole jurisdictional issue again in order to decide, was the first tribunal a tribunal of competent jurisdiction? There was very little guidance from authority, no binding court precedents, and only one relevant arbitral decision reported which counsel could supply to us, and that was a decision from the 1970s which supported Biden Inc.'s position. Here is the key passage of that ICC decision from 1979, saying the solutions adopted by an arbitral award enjoy the authority of res judicata vis-a-vis another arbitrator as long as the validity of the award has not been challenged before the competent state courts. It is not up to the second arbitrators to verify that the award meets the conditions necessary for its recognition by the judicial authorities. This would be tantamount to transforming the second arbitrators into judges of the competence of the first and of the regularity of the proceedings they followed. This cannot fall within the scope of their mission unless the parties have so decided. We concluded that that was a really important point. It's clear that the decisions by an arbitral tribunal can be reviewed de novo as a matter of jurisdiction, for example by the courts of the seat of arbitration on a challenge to the award, and also by the courts of another country where the award creditor seeks enforcement. Then the award debtor is entitled under the New York Convention to query the jurisdiction of the first tribunal and obtain a de novo reconsideration of that issue. But that's because those courts are exercising specific powers under the New York Convention or under the national law, which require them to, as it were, sit in judgment over the jurisdiction of the first tribunal. As another arbitral tribunal, we were not in that position. There was some academic authority tending to suggest that the ICC case was right about that, and in our view there were also very strong policy considerations. There are real principles of justice underlying res judicata, that no one should be, as the saying is, vexed twice in the same cause, and a strong public and party interest in the finality of arbitral decisions. And if a second tribunal can reopen an earlier determination and rehear it, then in principle, so could a third tribunal, and a fourth, and a fifth, and so on. There's really no end to the possibilities, and that's a pretty appalling vista of chaos if you think about it. But the key point, as we saw it, was the legal one, that the second tribunal, ourselves, was not hierarchically superior to the first. We were not in the same position as the supervisory court of the seat, nor like an enforcing court faced with an application to recognize and enforce under the New York Convention. And in this particular case, there was also an issue of Henderson abuse, that is, the abuse that occurs where you can bring forward an argument, but you decide not to. Then under Henderson principles, you should be precluded from raising it later if, in all the circumstances, it would be abusive to raise it later, having not raised it earlier. So, quite a brain teaser. Did raise some interesting questions. I'm very happy to discuss more. And just to wrap up very briefly, I want to mention as well there is some interesting and instructive case law about the role of res judicata when it comes to enforcement of foreign arbitral awards. An award may give rise to court proceedings in more than one country. There might be challenge proceedings in the courts of the seat, but also the award debtor may have assets in multiple jurisdictions. They may be chased around the world by the award creditor, and so there may be proceedings in different jurisdictions which have to address the same issues, like, was that award final and binding? Was there a contract or not? Was there some procedural injustice in the arbitration which would merit not enforcing the award? All those questions may arise in different fora in the same case. And so can one have an issue estoppel that takes a decision from one of those proceedings and makes it enforceable in another? Now, so far, the answer given by the English courts on that question is a big yes. In the Dalla case in 2011, there were obiter comments in the Supreme Court, as well as Court of Appeal, that a decision in the supervisory courts of the seat could found an issue estoppel, which barred a party from seeking a different outcome on the same issue when it came to New York Convention enforcement proceedings. UCOS and Rosneft was the first occasion when an English court actually decided an enforcement case based on issue estoppel. In UCOS, there had been an arbitration in Russia, and it went against Rosneft, the Russian oil company, and the award was then set aside by the Moscow court in a decision which smelled strongly of political interference. When it came to enforcement of the arbitral award, a Dutch court decided that it would not recognize the Moscow court's decision setting the award aside, and therefore they did enforce the award. UCOS also sought enforcement in England, and the judge held that he had to follow the Dutch decision because there was an issue estoppel. The Court of Appeal in England, though, actually overturned the judge on that point, saying that every country has its own public policy standards, and therefore it was wrong to treat a Dutch decision that Moscow court ruling should not be recognized on public policy grounds, wrong to treat that as being the same issue for res judicata purposes as the public policy issue in England. So it had to be readdressed on the merits in England. And then in the Diag Human case, that was a decision by an English judge that another state's court, I believe it was Austria, another state's court, when considering a New York Convention application for recognition and enforcement, that the award was not yet binding, and therefore there was a defense under Article 5(1)(e) of the New York Convention. That decision was capable of founding an issue estoppel. And drawing a contrast with UCOS and Rosneft, whereas public policy is really a matter where different forums can come to their own conclusions on their own standards, the question of whether an award is not yet binding or not is really a question of fact plus an application of common concepts, shared concepts of the New York Convention to particular facts. Finally, in Karpatsky Petroleum in 2020, there is an interesting comment from the judge which illustrates that it's really quite important to look at how a challenge in the supervisory court is decided. Basically, if there is a complaint of procedural unfairness raised in the supervisory court, and then that complaint fails, it should generally give rise to an issue estoppel, making it very difficult to relitigate the same point when it comes to enforcement proceedings in England. And with regard to the Henderson principle, if the losing party doesn't raise a particular ground of complaint of unfairness when challenging the award in the supervisory court, it may well be a Henderson abuse to try and raise that point later in enforcement proceedings. Ladies and gentlemen, I hope that gives a sense that res judicata and the law of issue estoppel can be really quite powerful and effective when it comes to managing multiple cross-border proceedings and the fallout from international arbitration decisions. The jurisprudence is still evolving. There is still scope for fresh debate and thinking, and we can expect more decisions on related issues in future. Thank you very much for your attention, and it was wonderful to join you today.
we are no doubt familiar, and I note that there certainly is at least one criminal practitioner here, of the recent developments over the last 15 or 20 years in various jurisdictions in relation to anti-corruption, money laundering, and organized crime, especially in relation to financing terrorism. Jurisdictions have scrambled to enact laws that would fight what is the modern way of attack by many criminals. No doubt the Kenyan Parliament has enacted the Proceeds of Crime and Anti-Money Laundering Act in 2009, and it also enacted the Bribery Act in 2016. Similarly, in 2002, the United Kingdom Parliament had enacted the Proceeds of Crime Act, and in 2010, we enacted the Bribery Act. However, the issue is that these provisions or these laws and regulations expose into the world or the realm of arbitration, especially into international commercial arbitration. Thus, the question which I will attempt to answer, which is, how can an arbitrator remain vigilant to such illicit conduct? Before I do that, I start by answering the question, which is, what does the concept of corruption and foreign bribery mean exactly? Well, corruption exists in many different shapes and sizes. It can be purely domestic, or it may involve foreign actors, and it involves always what is known as the supply, active, and the demand, passive side. Some forms are clearly, without any doubt, illegal, but others fall more in a grey area, and this is what gives rise to more confusion in the realm of arbitration. In international investment and commercial arbitration, the form of corruption that will frequently be at stake is foreign public bribery. That is, the bribery of public officials in the host state by a foreign investor. As a starting point, arbitrators can rely on the corruption definitions found in the international treaties. Bribery in relation to foreign public officials is, for example, defined in Article 16.1 of the 2003 United Nations Convention Against Corruption. I would not read the whole passage out, but it is quite broad in its implication. It implicates any foreign public official or official of a public international organization who directly or indirectly takes advantage, undue advantage, for himself, for some gain, in order to proceed with a contract or in order to proceed with any element of that contract. So it's a broad provision. Similarly, Article 1 of the 1997 OECD Convention on combating bribery of foreign public officials in international business transactions defines the giving of bribes to foreign public officials as any person intentionally to offer promise or give any undue advantage, whether directly or through intermediaries, to foreign public officials, would be considered as a bribe. One point to note here is that bribe it doesn't have to be given at that stage. It could be something that is given later on. Even that promise of a bribe will be considered, would satisfy this section. Before I launch into what an arbitrator may decide to do in tackling such a problem when faced with it, I would like to discuss two particular cases which are of interest. The first one is regarding a French company called Sorelec against the state of Libya. Libya entered into a construction contract with Sorelec, a French company, in 1979. A dispute erupted, as it does at times, in 1985, resulting in ICC proceedings being brought by Sorelec for a sum of $109 million plus interest. A consent award was signed by the then Justice Minister of Libya, Mr. Omran, where Libya agreed to pay $230 million within 45 days, failing which they will have to pay $452 million, which was the initial sum of $109 million plus interest. Libya applied to annul the award to the Paris Court of Appeal on various grounds, including that the international public policy had been violated as Sorelec obtained the consent award through bribes and corruption. This case was instrumental in shaping what convention, which I referred to earlier, a very broad definition, and to the United Nations Merida Convention of 2003. Some of those signs were that the civil war in Libya at that time and had given rise to corruption in that country. This was widely form the basis of entertaining the allegation for the arbitrators. The other sign was that Mr. Omran himself, in proportion to the work done. So work is small, but the commission is huge. That's a telltale sign. That would be a non-commercial decision, and that certainly should be scrutinized. There's no tangible work done, so everything exists on paper, or there's only a small amount of work done. That, again, is a telltale sign. And in order to establish that, of course, the arbitrators would look at documentation. And if it becomes more difficult for the intermediary to provide evidence, then one can conclude confidently that there is some question marks here that need to be explored further. The qualifications of the intermediary to perform the work for which they are engaged are not sufficient or non-existent. If you have an engineering project, the intermediary that's engaged to deliver the project, if they don't have that those engineering experts, then of course that should raise that red flag. Often percentage-based remunerations are also a red flag. The time taken by an intermediary is rather short. So if you have a large-scale project and it's delivered on paper very quickly, that too should raise red flags. The list goes on and on, but it's all factual based, and it's based on a case-to-case basis. The arbitrators should then look at national and international law. In international investment and commercial arbitration, the parties choose in principle the applicable law, or in the absence of a party's choice, the arbitrators define the applicable law. In cases of alleged or suspected corruption, arbitrators will in first step, identify the applicable international treaty provisions, two of which we've already heard about today, and national contract law provisions that declare contracts to be void if they are contrary to the law or public policy. In a second step, the arbitrators will refer to the provisions of national or international law according to which bribery is illegal, and then apply these provisions as a basis for invalidating the transactions. In this second step, besides the applicable law as chosen by the parties, other rules may apply according to the criminal law proceeding principles. There are certain steps that an arbitrator can take, and I'll go through them one by one. Firstly, the arbitrator should decide how does he become aware in a case about corruption. We've gone through that, the red flags. The second step is, what does the concept of corruption and foreign bribery mean exactly? We've defined that through the international treaty provisions and the national law that would be applicable in that instance. And the third step is which norms and international law is applicable. We've just heard about that. This leads us to the fourth step, which is sua sponte or sua moto investigations. So investigations taken by the arbitrators on his or her own volition. If an arbitrator sees signs of corruption, whilst they are not state judges, they do fulfill a certain public function, because in general terms, arbitral awards are enforceable like court decisions, as we've heard from Simon Mills earlier. Furthermore, arbitrators have a duty to issue an enforceable award. If arbitrators ignore issues of corruption, there is a risk that their award will be challenged in front of a state court in set-aside proceedings or at enforcement stage on the ground that it is contrary to national or international public policy. Therefore, if an arbitrator sees signs of corruption, they should, if none of the parties raise the issue of corruption, investigate and ask questions on their own volition. Step 5 is in relation to the burden of proof and the circumstantial evidence and red flags. This will depend on the arbitrator's legal knowledge. Of course, burden of proof is a legal concept, and as lawyers we all know that it's not as straightforward at times as it is taught to us in the textbooks. In principle, the applicable law as chosen by the parties determines the burden and standard of proof regarding allegations of corruption in a civil proceeding. Sometimes the applicable law may not clarify the applicable burden and standard of proof, and hence comes the arbitrator's personal knowledge of law and how he decides to do so. The arbitrator should ask the parties for evidence and then decide on the standard of proof. This leads us to step 6, which is whether or not an arbitrator can draw adverse inferences, a common goalpost that our criminal colleagues deal with in criminal courts on a regular basis. If arbitrators request a party to produce specific evidence to rebut the corruption allegation or suspicion, and the party fails to do so without a convincing reason, then arbitrators may draw adverse inferences from this fact. Arbitrators should also be alive to any national criminal proceedings. Sometimes there will be parallel criminal investigations or proceedings in one or more jurisdictions next to the arbitration proceedings. Criminal proceedings may be launched before or after the initiation of the arbitration, and they may be ongoing or concluded. Understanding and knowing the facts in relation to those criminal proceedings is important when facing allegations brought by a party or on their own volition of corruption and bribery. Step 8 would be, at what stage of the investment did the corruption occur? So if it is an investment-related arbitration, determining whether or not the corruption was present before the contract was entered into, or whether bribe was given at a later stage, will also inform the arbitrator as to how to deal with the issue. To put it simply, there are 2 stages at which investors may pay bribes. Arbitrators should consider whether bribes were paid in order to procure the investment, or whether the investor lawfully obtained the investment but paid bribes at a later stage during the performance of the investment. It must be kept in mind that bribe payments connected to the procurement of an investment do not have to be effected before the investment is actually procured, but can occur at a later stage. Furthermore, according to the standard set by the international treaties, foreign public bribery does not require that any bribes are actually paid. It is sufficient if bribes are offered as promised. The final step, the step 9, is what is at stake. Arbitrator must be alive to that too. In international commercial arbitration, it may be that the main contract was procured by bribery, but it is also possible that a party attempts to enforce a contract for bribery. The principle that applies in international commercial arbitration means of separability means that the arbitral clause has a separate existence from the main contract, and in principle remains valid even if the main contract is null and void. Therefore, in commercial arbitration, corruption generally does not affect jurisdiction of the arbitral tribunals, but is discussed at the merit stage. The arbiter should consider nullity if a party attempts to enforce contracts for bribery, and in particular, contract procured for bribery. That, in a nutshell, concludes what is at times a complex topic, of course, in relation to facts and evidence that one has to explore through. And that brings me to the end of my element of this panel speech. If there are any questions, I would be happy to take them at the end when we have questions and answers. And at this juncture, I pass the stage on to Mr. Simpson, who shall carry on in relation to fraud and litigation.
Thank you very much, Hamad, and thank you very much to the Law Society of Kenya and to the Bar Council of England and Wales for inviting me here today. It's really a pleasure to be here. I first came to East Africa in the mid-1990s when I was working for a charity in Uganda, and that's when I first came to Kenya for the first time. Travelled very extensively around this part of the world and other parts of Africa, and been back many, many times. And I have to say that all of the good things that I've seen in this part of the world since that time have come almost exclusively from advances in the rule of law. And at the same time, I have to say that all of the bad things I've seen have come from setbacks in the rule of law. So this is a very timely topic to be discussing today, and I'm very pleased to be part of it. Nowadays, I'm in chambers in London, 3 very well-known buildings, and I practice mainly in the fields of banking, and I have acted in a number of really quite large fraud claims involving banks. And I'm going to talk about 3 of them today, mainly to give you some kind of war stories, to give you some colour as to how international fraud cases operate in London, and why London is such a magnet for those kind of cases. So just to outline the case I was going to talk about, I acted in a Saudi case a few years ago, which arose out of the collapse of a family company in Saudi Arabia, where the company collapsed owing $8 billion to 128 banks. And their defense was, we have been defrauded by another family member. I acted for one of the banks. I acted in a Ukrainian case, which arose out of the collapse of a bank in Ukraine. The bank had been owned by an oligarch, and the Deposit Guarantee Fund of Ukraine was pursuing him and my client, which was a corporate services provider, to recover those funds. They wanted to do that through the courts of London. Most recently, I've been acting in a Thai case, which arose from a Thai renewable energy entrepreneur being forced to flee the country for, he says, were political reasons, because he was facing charges of lèse-majesté, so insulting the royal family. And this resulted in a series of transactions by which he had to divest himself of his holding in a renewable energy company back in Thailand, a wind farm company. And in these transactions, he said that effectively he had been expropriated, asset stripping had taken place. And he brought a claim in the English courts against 17 defendants, including my client, which was a bank in Thailand, a bank owned by the King of Thailand, 25% owned by the King of Thailand. That case kept us in court for 5 months last year, and we got judgment a few months ago, and I'm pleased to say that everyone lost apart from us. So why is it that England is a magnet for international fraud cases? Well, first of all, English law, English jurisdiction clauses give rise to a lot of cases. The Saudi case arose from the fact that many of the lending documents had English jurisdiction clauses. More commonly, I think, actually, it's a combination of the English law of unlawful means conspiracy and English rules on jurisdiction. So it tends to be the case that if you can find yourself an anchor defendant resident in England and Wales, then as long as then you can bring in a whole cast of characters from around the world on the back of that anchored defendant. And that was effectively what happened in the Thai case. Other cases have been brought because people are seeking a fair trial. There are which they say that they would not get at home. There are Russian oligarch cases which have been brought in London because both sides say that they can't get a fair trial back in Russia. The Ukrainian
power of the arbitrator to deal with that, but it's still a balancing act, but we're heading in the right direction. So with that, I stop my short presentation, and I'll be happy to take any questions on some of my experiences. As Hamad said, I was shortly involved in all the texts on arbitration refer to the World Duty Free case versus Kenya as the celebrated case, the well-known case. Yes, I was involved. It makes interesting reading, tells you a lot about your own country. The big debate is whether you should lose the right to pursue a claim worth billions of shillings because you handed a basket of eggs to a public official. That the jury is still out on that. What is the degree? How many eggs should it be, or before you lose billions in investment? So with that, I rest my case. Thank you.
Thank you, panelists. It's been an interesting presentation from all of you. I'm sure we have a few questions on the floor. Some of the issues that have been talked about, I will probably raise some questions even for myself as the moderator. When I think of a situation where cases of bribery are being arbitrated, and in the case of Kenya, would that be something that will be popular? I think we would prefer to litigate issues of bribery and fraud and actually put them on the newspaper for publicity. So over to you. Any questions? You can direct to any of the panelists.
Hello.
I mean, Hamad did.
Did I? I would be very happy to take any questions. I think the hands that did come up for you have gone down for me. Yes, please.
Yes.
Thank you very much. Just to thank the presenters for their presentations and to raise a couple of observations with respect to that. The first one is, and mine, when I finish, I think it's more of a question of what interventions then can we make? Because in 2013, when I was doing my master's, my research paper was on the question of public policy limitation on enforcement of international arbitral awards. And the recommendation then that I was making is that public policy is actually like an unruly horse. It will go as far as the court that is sitting on that matter wants it to go. So I think 10 years later, it will seem from the discussions today that it is still an ongoing debate and therefore could potentially affect the place of Kenya, of course, as well as other countries, especially because we are not so contracts will have Kenya as the place of arbitration. So perhaps it's an opportunity that we may want to consider even in our foreign judge.
order. But in my presentation, my name is Amanya Cohen. I'll be moderating the next session, which will be very interesting. And I hope they always say that you save this side. Yeah, I know we had lunch and it was a heavy one. But among my, for the next session, we have different presenters. And I will, on our panel of speakers for today, I have Miss Nancy Williams. I hope my pronunciation where I come from, forgive me. I don't want to mention other names. I will make the introduction a very clear one. We have also Mr. Osinunga Oladere, and also on part of our panel we have Mr. Kamodo Waiganjo. If I may start, for those who are listening, Nancy is a barrister who practices in the areas of children law, court of law, inquest, and international human rights. She has extensive international experience and previously worked at the International Court of Arbitration in Paris, the United Nations Development Program, Access to Justice Program in Sierra Leone, the Birmingham Center for the Rule of Law, and in the International and Group Claims Department of the leading UK human rights law firm, Lady. She was involved in large group actions. Nancy has also collaborated with the UK Sierra Leone Pro Bono Network to draft the sentencing guidelines and practice direction for the Anti-Corruption Division of Sierra Leone High Court. To be sincere to you, the said guidelines were published in October 2020. Thank you, Nancy, for that. I hope I have captured to some extent. Yes, another person we are having, Mr. Oladere Osinunga, is a barrister, solicitor, and an advocate of the Supreme Court of Nigeria. When we talk about Nigeria, you know what we mean. For those who are like me, in the evening we meet. He's also admitted counsel to the International Criminal Court and the Kosovo Specialist Chambers, both in The Hague, Netherlands. We are very honored to have you here. Oladere is currently holding litigation and prosecution lawyer at Barre Metropolitan Borough Council. He was previously prosecution advisor of the Pan-American Development Foundation in Bez, and has held position as a lawyer previously the London boroughs of Camden, EU in Kosovo, and the CPS. Oladere has been engaged as a criminal justice consultant by the International Development Law Organization and the Pan-American Development Foundation in the Bahamas. For those who have never been in Bahamas, see me, I will tell you what to do. I myself have been there with Maria Mbeneka. So, then we have one of our own, who is not new to us, one and only Mr. Who was a former commissioner at the defunct Commission for the Implementation of the Constitution. Kamodo has been an advocate of the High Court for more than 30 years. For those who, I met a colleague, for those who want to be 30 years in practice, meet him after this session. He holds a bachelor's and a master of law degree from the University of Nairobi and a certificate in public finance and decentralization from Duke University, US. Kamodo is currently undertaking a PhD at Nairobi University. In years of practice, private practice, he has handled commercial, constitutional, and administrative law issues. As the commissioner at the CIC, he oversaw legislative development in the devolution and public finance. Mr. Kamodo Waiganjo has written on several subjects, including implementation of a constitution in Africa and writes weekly columns. Mr. Kamatho Waiganjo is also a director in numerous public and private entities, including the Law Society, Kitio Chashela. He is a husband, father, and a grandfather of 5. I've been told to mention that. So here we are. And your moderator for today is one other than Amanya Cohen, who is a member and a treasurer for the Law Society. So where we are, we'll start with Ms. Nancy. The concept that we are doing today, yes, the function and what we are doing today, the next session, we agreed that it would be interactive, informative, and interesting. As how it will be interesting and how it will be informative, it will depend on us. So as we begin, we want to start from home. Mr. Kamodo, we want you to tell us, to the extent of whether, because you were part of the persons that were in the drafting of that constitution, on that commission, we want you to tell us on whether Kenya is at or is going to be in terms of the rule of law. Where are we? I will begin with you. Where are we in terms of the rule of law?
To answer?
Yes, yes.
Oh.
Yes, yes.
All right. Wow. I think from where we have come from, for those that have followed Kenya's history, we look at Kenya pre-independence, post-independence up to about when we promulgated the new constitution. I think we come a fairly reasonable distance in many respects. I think there are some areas where we have made great strides, but there are some others where we are frailing. We're just, struggling. And if I was to take the key components of the rule of law, which is about knowing the rules, complying with the rules, and ensuring that everyone is subject to the rules. I think in terms of the people's understanding on the key issues of governance, the key constitutional questions, because we went through a very the level of public engagement in the making of our constitution was quite diverse. So I think in terms of knowledge of what the broad rules are and around which the country is governed, I think I would say that we have come quite some distance. And I think in terms of internalizing the existence of a constitution that has checks and balances, I think you'll find that that is known and accepted across the country. In terms of compliance with the law, you find that if you look at the intentions of the Constitution, the intention of our Constitution 2010 was particularly to constrain executive power. Because we came from a history where we had an executive, what was called the imperial presidency, that basically controlled all aspects of governance. It controlled the judiciary. You could not be appointed a judge unless the president allowed, and if you gave decisions that the president was unhappy with, you lost your job. And there are many judges, people like Justice Coffey and others, who are fired because of making decisions that the government was not happy with. And that is what we were running away from. If you look at where we have come, where courts are able on a regular basis to give judgments against government, and it's routine, as to whether the judgments are complied with. The fact that the courts are confident enough to give judgments against government is a good development. I think where we struggle is in terms of ensuring that there's total compliance, particularly by the executive, on many of those of the judgments, particularly the judgments that are given against government. But the reality is that in 70-80% of the cases, the government complies. In fact, a case in point is the ongoing, for those of you who are Kenyans, is the ongoing evictions in Mavoko. Government has been wanting to evict those people for the last 2 years. The only reason they had not is because of subsisting injunctive order. And so there's a sense in which, or BBI last year, the government was totally committed to a process of constitutional change and had invested billions of shillings and a lot of political capital. And the courts were able to say no. And the government complied reluctantly. We remember when the elections were nullified in 2017 and the government threatened to revisit. And I think they did revisit in some respects. But I think what I'm saying is that in terms of compliance, in terms of the courts being confident enough to give judgments against this government, that has happened. And so there's a sense in which that level of rule of law, which is about the law being everyone being subject to the law, I think we have made some strides. I think the areas where we have struggled is particularly in terms of separation of powers, which is a key component of the rule of law, which is that you constrain power through checks and balances. The intention of the Constitution was to have a fairly independent parliament that could hold the executive accountable. That in reality has not happened. Our parliament is very much an extension of the executive. And it does what the executive wants for various reasons. You know, if you look at the budget process, the government is the one that determines a budget allocation. It used to be the intention was that it was parliament that would make budgetary allocations. But the reality is that the president has the power to say we're going to allocate X amount of money, you know, and parliament just follows. So in terms of acting as a check on the powers that the executive parliament has done poorly. If you look at the questions of things like public appointments, it used to be that we would have a very vibrant process of vetting. But those of you who live in this country know that in the last 10 years, 13 years of the Constitution, I think 95% of what the executive recommends for appointment is affirmed by Parliament. If you look at the final thing I'll say is in terms of the accountability institutions, the other accountability institutions we expected to do a good job of keeping a fair check on the presidency and the executive was the institutions like the Auditor General. And the other institutions, the anti-corruption institutions, and many of these performed very well in the first 5 years of the promulgation of the Constitution. Most of us remember the first Auditor General, Ouko. Many of us will remember the work done by the CIC, which I had the privilege to serve in. Many of us will remember the Office of the Ombudsman, led by Honorable Otiende Amolo. Those institutions were doing quite significant work in terms of checking the executive. But I think the executive then learned that recognizing that we are still working with institutions that are still fairly new and are transplanted, and we operate in a plural system, you know. I still think that we have made some significant strides, but there's still quite a long way to go. And of course, we also still have to look at it from the perspective of the people. What about the level of compliance with the law where the public is concerned? And how much have Kenyans, the citizenry, internalized the whole concept of the rule of law themselves? And I think that is an ongoing debate, so that I do not hog all the time. Thank you.
Thank you. I think we'll hear from my good friend. We always balance.
I think in terms of the UK model, it's fair to say that we have a fairly robust adherence to the rule of law, particularly amongst the judiciary. I think that the threat to the rule of law in the UK come from a variety of sources which are actually external from the judiciary. And not to finger point or blame, a lot of it comes from the government in two ways. First, legal aid, which is a means by which some of the most vulnerable members of society get access to lawyers to represent their cases, has been systematically scaled back by our government. So it means that some people who are dealing with really important issues in their lives often go to court unrepresented, with no understanding of the law, and more often than not, they're against state bodies who have legal representatives, and sometimes the best legal representatives because they have deep pockets. I should say, because I have experience of dealing with litigants in person, that judges and barristers, because we have an overriding duty to the court, do our best to assist those individuals, but they are significantly undermined by not having access to legal representation. I think the second is the government sometimes seeing decisions which uphold the rule of law as being a threat to their authority. So I think the two most significant examples I can think of are first when the courts decided that when Boris Johnson prorogued Parliament, that was unlawful. There was a front page on one of the leading tabloids in the UK called the Daily Mail that had pictures of the 3 Court of Appeal judges that made that decision, and underneath that picture it had the title Enemies of the People. And that newspaper has a lot of traction, it's very popular. I think it's the most popular tabloid newspaper in the UK. And it really put the spotlight on those judges and created a lot of talking points among members of the profession of, I think these were points that were discussed earlier. Can we do our job safely if when we make decisions that uphold the rule of law, we are criticised by the public and the government? And the second example, I would say, is particularly in relation to the government's policy around immigration. And there are groups of lawyers that are really fighting their best to uphold the rights of asylum seekers to have a fair crack at justice and the legal system in the UK. And those lawyers are increasingly becoming under attack by the government. You hear the government in Parliament referring to lefty, woke lawyers who they've even made allegations, unfounded allegations, that some of these lawyers are corrupt when it's not true. So although the judiciary, I would say, and the legal profession in the UK is doing its best to uphold the rule of law, it is under threat and it is difficult to make decisions sometimes which are contrary to what the government and popular opinion is at the time.
Thank you. We'll hear the perspective from...
Well, I think I was actually going to take my leave because I was thinking of using AI and having a hologram and then giving a response. But Kamoto has actually said the same. Nancy has also given her view on the issues facing the rule of law, both here in Kenya and also in England and Wales. For England and Wales, I mean, particularly the area I practice, apart from the public international law space, within the public law, I think there are certain areas where there's been cuts in legal aid, as well as access to justice, which also interfaces on legal aid. There's been, over the years, since I've been practicing in the UK, a lot of courts have closed down. The reasons for that, particularly with the coalition government of David Cameron. I don't want to be political. I mean, they closed down a lot of courts when we had the coalition government. And also, legal aid is no longer available in areas like housing, which is a key human basic right, because everybody is entitled to the right to be housed. We still have we have a significant of people living in public housing in the UK. So I represent the local authority where I work in Bury, and a lot of the litigants who are council tenants do not have access to lawyers, to legal representation. And if you're going to lose your house and you don't have access to legal representation, and we, of course, in the UK, are supposed to be a first world country, even though that term is not usually quite popular. So you look at those areas, and then there's been talk within the current government to live in the European Convention of Human Rights, which is a key plank on which our constitutional rule is based on. Because as you know, the UK does not have a written constitution, but we have certain acts of parliament which are actually constitutional in nature. And the European Convention on Human Rights, embedded in the Human Rights Act of 1988, is one of those conventions. So basically, if we're saying we're going to withdraw from the Council of Europe Treaty, which is the European Convention of Human Rights, then we're in violation of international law. When we look at the history of rule of law, as propagated by Albert Dicey, the 19th century UK jurist, there were 3 planks on which rule of law rested. 1, supremacy of law. 2nd, equality of law before the law. And the 3rd, certainty of legal process. That is the spirit of legal certainty. Because there is no point where you have litigants going to court and they're not certain of the outcome of that process. So where you have a lot of government interference, either through ingenious, and kind of covert ways in trying to undermine the administration of justice, what do you have? You have the public losing interest in justice. I remember years ago, that famous son of Kenya, Barack Obama, gave a famous speech in Accra, and one of the things he said, one of the bases in which you build strong institutions in a democratic country is not by having strong men, because we know, but luckily, Kenya has been kind of an oasis on the hill, one of the most stable countries in Africa, even though if you don't like to say, but I will say that, because Nigeria, we've had our own challenges as well, obviously being Nigerian by background. But Kenya, when you look at the African continent, has been quite stable, so you've built strong institutions. How that then works is a different issue entirely. And, we Africans, we always talk in proverbs. When you look at all the three institutions of state, of course, you can count the press as the fourth institution, your judiciary, your executive, and your legislature. There's an African proverb that say when two elephants are fighting, what happens? The grass suffers. In Kenya, you can say when two locusts or grasshoppers are fighting, the crow gets happy. So when you have the three different branches of government being undermined by one because the executive holds the purse strings, then of course you have issues with guaranteeing the independence of the judiciary. So in as much as the UK is kind of advanced and is a model which Kenya looks up to, and other countries in Africa, we also have our challenges as well, as you've heard from the speeches that were given this morning by Barbara and also by Fred. So those are issues we touch on, and it's not really hunky-dory in the UK, as we like to say, but it's things that obviously it's work in progress. I mean, the shared legal tradition between Kenya and England and Wales, and of course we're hoping to learn for more, and with greater interaction, we're able to achieve that process.
Are we at the same page? The audience, are we okay? I told you that it would be very interactive. It's the beginning. Now, and this one I want to ask my good friend, Senior Mr. Kamotho. We, at the concept and at the core of the rule of law, we are making an assumption that all the three arms of the government are at par. Where do we put the balance between separation of powers, accountability, and good governance? Because there's an assumption and a principle by the rule of law that there is separation of powers from all the three arms of the government, but when it comes to accountability, the other arm of the government seems to be. How do we put a balance on these three arms of the government in terms of the rule of law?
Well, thank you. The intention, of course, purely from a conceptual perspective, is to ensure that these things move together. Because the rule of law encompasses all those aspects that you're talking about. And ultimately, when, for example, our constitution was promulgated, the intention was to have very strong institutions of accountability. Of course, part of the accountability process is the checks and balances that arise from the separation of powers. And so these are not separate and distinct concepts. These are things that, in a sense, move together. But what you find, which is an area I find interesting when you look at this part of the world, is that while it is important to create strong institutions, institutions in this part of the world are also about people. And so that what you find is that even though the law, the letter of the law is very strong and you have very strong institutions, the character of the people who lead those institutions sometimes makes a difference in terms of the trajectory of growth of those institutions. I, for example, believe that the reason our judiciary has taken an independent stand separate from other parts of the three arms of government has to do with the first Chief Justice and the character of the first Chief Justice. So that what you then do is you build a particular kind of tradition. And unlike other places where institutions matter more than the individuals, I believe in this part of that individuals matter as much, sometimes more. I've done a study of the chapter, I think they're called chapter 9 institutions in South Africa. The character of those institutions depend on who is the leader of that institution. The public, is it called a public protector? If you look at the difference between the first public protector and the current public protector, it's a whole lot of difference. No change in the law, not what has the difference been? It's the individuals who run the institutions. I said that to emphasize the point that it is not enough to just look at what the letter of the law says. You have to ask about context, and context has to also do with the character of the persons who lead the institutions. That's not to downplay the place of institutions. Now, if you look at where Kenya has gone in terms of strengthening institutions, even though you have the letter of the law, for example, that talks about an independent judiciary, the executive is still able to use certain powers that it has to still ensure that it can control some of the powers of the judiciary. In the last administration, the president refused to appoint judges that he was unhappy with. You know, even though the constitution requires the president to appoint, but because there is no recourse to what you will do if the president doesn't, then the president, in a sense, even though the law is very clear, just decides not to. A fresh president comes without changing the law, without any change, and appoints the same people. You know, and that tells you that the character of the person is just to emphasize that. So that sometimes we downplay the role of the persons who lead institutions. The last point I'll make is that even in terms of the growth of these institutions, even on the growth of an institution like the judiciary in Kenya, we still have to recognize that as an institution, it doesn't have the sort of strong foundation that will be able to withstand overwhelming pressure from the executive. And so, and I believe my friend Ochel Dudley would disagree, the reality is that even for those of us who undertake constitutional and politically delicate litigation, we need to recognize that we put the courts in a position, and that is where a lot of these matters are not heard, where they themselves recognize they're still not strong enough to be able to go head to head with the executive. Because if they do, the executive has enough tools to weaken the judiciary. And so until that point where the psyche of the public has settled enough so that the people support the judiciary against the executive, we have to be very careful about how we manage particularly politically sensitive litigation, because you could end up actually destroying an institution, notwithstanding its very strong tenets in the letter of the law. And I think that is something that even as a litigating society, the laws, we need to internalize. What is it that we need to do to ensure that by the time we expose the judiciary to the full assault by the executive, that it has retained the kind of strength that it can withstand that power. And so what I'm saying is that you have to always look at these things in context. If you just read the letter, the Kenyan constitution is one of the strongest in terms of institutional capacity, institutional infrastructure. But in terms of how it operates, you have to look beneath it and ask who it is who is overseeing it, who is in charge, who's in control, and who is against.
Maybe, Senior, to capitalize on what you have just said, and maybe for your wisdom, since you are in that commission, we want us to understand, and there are many of us young lawyers who were not yet admitted as at that time, we have seen a transition in terms of the electoral process. The 2013 decision in the Supreme Court, 2017 decision in disguise of the rule of law, and the 2022 decision in terms of the rule of law. What is your take, and to be specific, on the issue of strengthening these institutions regarding judiciary, executive, and our state agencies and organs like IEBC?
Now, I'm one of those who believes very, very honestly that not purely as a matter of law, but purely as a matter of strategy, that the 2017 decision to nullify the presidential election was a bad decision. As a matter of jurisprudence, it's a very good decision. but as a matter of pragmatism. And because, and I'll be honest with you, until that time, the executive had not considered the judiciary a threat. And so it had allowed the judiciary to grow. If you remember, even in terms of funding, those of you who practice in the courts know that's the time that the judiciary had the highest budgetary allocations. That is how they were able to do courts. They were starting to do courts all over the country. That is the time that the judiciary, the executive did not interfere with the appointment of judges. They were not interested. In any case, these are institutions that were growing. That is the time we could have Willie Mutunga and Justice, our immediate Chief Justice, Maraga. That is how people like Justice Maraga could become, even though they were known to be very, very strong and pro-people. That is how they could become Chief Justice. The minute the 2017 decision was made, the executive regrouped and decided this is a problem that needs to be managed. And the judiciary at that time was not strong enough to be able to withstand the executive. And so what has happened over time is that judiciary has been weakened. Now, we can celebrate the decisions they have made. But those of you who have tracked the decisions of the judiciary, they have either become more hesitant, yeah, or they have ensured that they either don't give decisions, they rarely will, sometimes they'll give decisions that are ridiculous. But most of the times what they have done is not to give decisions and postpone anything that could get them into coalition with the executive. So the point I'm making is that sometimes in a country like this in transition, when we are coming from a particular point of a very autocratic, strong executive, one has to manage the transition very, very carefully until the institutions get to the point where they're strong enough to withstand. When you even have partners, as it is now, the judiciary doesn't have partners, even in civil society. The civil society, you don't have partners. You have civil society that is, other than Katiba Institute, most of the institutions in civil society are gone. The religious sector is itself swallowed by the executive. Who else used to be there? The media is owned by private sector, which means its interest is profit. And where do you get most profits? From government. So in a sense, as a judiciary, you are by yourself. Does the judiciary have the power to withstand that? I doubt. Now, I'm a pragmatist. I stopped being an idealist the minute I turned 50. I believe that first you have to survive so that you can learn to fight. I think some of the decisions made, particularly in the second term, sometimes were not always very wise in terms of the broader interest of the growth of the judiciary. Now that's of course a controversial point. We're jurists, we should be more concerned about the rule of law and about whether we follow the constitutional principle. But I think in a democratizing country like this, I think one has to also be pragmatic. That's just my view.
Thank you. Wow. That's, I think, a clap of hands, and I mean for my colleague from the, yes. I know Dudley will have a different view. Let's hear, yes, in Wales, the UK, we have seen some of the decisions that are coming from your courts. Because in Kenya, we're seeing, as my colleague says, there's a lot of interference. Some of the decisions are being made as to the circumstances of the case. And there is now a movement in the UK to legalize some of the rights. Is it at the heart of all this? Where in the UK is the cornerstone in terms of the rule of law? And is there any interference that what we are facing here, you also face the same challenges?
Well, I'm happy that we're having this discussion because everybody will think the UK is perfect. Well, we're kind of perfect, but not utopian. I think Nancy touched on some of the issues earlier on. We talked about proroguing of Parliament by Boris Johnson, which was ruled unlawful. And believe it or not, that action actually started in the Court of Sessions in Scotland. We have a unique system where we've got powers devolved. We're a unitary system just like Kenya is. And this is why we need to understand the governance structure, not just the courts, but the governance structure in the UK, which I know most people are familiar with. But we had an anachronism before the devolved government, which was introduced by Tony Blair, where you had a West Lothian question. And basically what that meant was that English MPs, I hope I'm getting it right, I hope I don't mix myself up in the model here. English MPs were deciding, couldn't decide matters relating to Scotland Well, Scotland, the Scottish MPs could decide matters related to England devolved powers in Parliament because England doesn't have powers devolved to it. So thereby, they then created devolved parliaments in Wales, in Scotland, as well as Northern Ireland. But what's happened along the line is we've now had some of the councils in the UK, we've had mayors elected, particularly for London, and there's a history behind that because initially we had the GLC. Margaret Thatcher didn't like GLC, so she scrapped. There was just a bill of parliament that scrapped GLC overnight. And then we had the period where there was no government for the 32 boroughs in the whole of London. But what we've noticed, particularly with the recent government, I know the Bar has been quite forthright in his approach in addressing those issues, as well as the Law Society, is when you look at the constant, this has been a recurring theme since we've had the Tory government since 2010. I don't want to sound very political. We're supposed to be independent, of course, as officers in the, and ministers in the Temple of Justice. But it's been a recurring theme since the Tory government came in that they want to withdraw for the European Convention of Human Rights. And why is that? Section 6 of the Human Rights Act allows the courts to rule incompatible if there's any rights by public authorities in the United Kingdom which are contrary to the European Convention of Human Rights, which is embedded in the HRA, in the Human Rights Act. So government has seen over the years that they've had a number of losses in court, both from first instance all the way to Court of Appeal, and also to the Supreme Court as well, and they're not happy. So what do they want to do? They want to withdraw from the European Convention of Human Rights. But what does that tell you? Especially now where we live in a kind of world which is changing with the crisis in Ukraine, the crisis in Palestine, and of course, instability in the Sahel region in Africa. If the UK then says they're going to withdraw, then other countries are going to say, well, you've withdrawn to human rights. It then gives a blanket check to this some of these big men. And we've also seen them in our neighborhoods as well. Recently, there was an election in Poland, and the reason why the government lost was because of all the infractions and all the interference which the last government in Poland had done with the judiciary. I have friends from my days working for the European Union who are Polish judges, Polish lawyers, and they had a similar problem. So hopefully with the new government led by the former chairman of the European Commission, Donald Tusk, that will be able to address some of those problems. Hungary, with Viktor Orban, too, is a similar situation as well. Of course, Belarus and Russia, they've been kicked out of the, or suspended from the Council of Europe. So in our neighborhood, we also have bad guys, bad hombres in our neighborhood. When I look at Latin America, when I worked in the Caribbean, Guatemala is a big problem as well. I mean, you look at all the countries. So it's not a problem that is unique just to England and Wales and also to Kenya. So as much as we're trying to address those problems, but because we have a strong bar, which I'm happy Kenya too has as well, they're able to address those issues and fight those fights on behalf of the legal profession, on behalf of the public, in addressing those challenges. And of course, by doing that, then increase the public's confidence in the administration of justice. Because once you lose that, then what's the hope for the common man?
Maybe before you... okay.
Yeah, I just want to pick up on something that Oladele said. So I would say that we do have interference with... I wouldn't call it with the judiciary, I would call it with the tools that the judiciary uses. So Oladele gave the really pertinent example of the government has actually now been talking about this for a long time, but withdrawing from the European Convention on Human Rights because of the reasons that Oladele has given. And we also see a very reactive sort of legislative process. So if the courts come out with a decision, for example, that safeguards or boosts the human rights of a particular group of people. So the best example I can give is in terms of immigrants. We see the government reacting by putting through legislation that makes it more difficult for immigrants to have their rights respected in the UK or to have a fair process going through trial. So what we see is not interference with the judiciary per se in the direct way that was explained happens in Kenya, but rather a more sort of discreet, insidious interference by trying to weaken the tools that the judiciary has to ensure that the rule of law is upheld.
There's a question that I think which you raised. Maybe my colleague, Mr. Sinugu, you'll just to answer this. You have told us in Kenya we borrowed a two-tier system. That is a devolved system, where we have the Senate and we have the Parliament. And when you look at the instances you have given, it seems we borrowed the same concept. But the challenges we are having in the country, in this country, is in terms of how the laws are being made and whether there would be, whether the Senate will apprehend or recognize. The issue of recognition has been a problem on what the functions they do. In terms of implementing the law, they feel that the laws should pass through the Senate. That is the Senate. The Parliament feels that they are the ones who should be the overall. So it has created a rift, and we ended up either in court or where. I don't know, and coupled with that, when we're answering that, how is it that when Belarus, when France is fighting, or when there's Brexit, these countries, Wales and all that, they come out fire-blazing. But when other entities which you don't support come out in terms of the rule of law, now we're seeing what is happening in Israel and Gaza. Everyone is quiet. When ICC was in Kenya, Wales was kept quiet. But when those superpowers are fighting, we see you. How do we then, as Africa, in terms of the world, and how do you look at it? When these big so-called superpowers are fighting, they gang against us. They are not part of the Rome Statute. They're not part of the EU, but they are trying to interfere. What is your take, and how is it in terms of the rule of law and the independence of institutions in that country?
Well, I think when I look at the United Kingdom, of course, we have the House of Lords, and one of the interestingly, there's always a lot of agitation that is to scrap the House of Lords in England, but in United Kingdom as a whole, but it's not popular, and I'll tell you why. We have a lot of cross-bench peers, as well as peers even from conservative Labour Democrats, who are the most hardworking, and they've been the ones who have been most critical of the legislative process. So wherever the government wants to railroad legislation through the House of Commons, the House of Lords have been a check. And of course, there's a Sewell Convention, which says that wherever there's an act of Parliament, which is a manifesto declaration, then that has to be passed through the House of Lords. But even with that, there's still a lot of scrutiny from the House of Lords during that process. Now, looking at it in terms of how we enforce international law and compliance with international law, because that is a basic plank of any legal system, including ours, even though we are what is called dualist tradition countries, whereby international treaties are not directly implemented from the time you sign it, they're not self-executing, but it has to be implemented through Parliament. I think Africa as a whole, through the African Union, through the RECs, the regional economic communities, should be speaking as one voice. So I know there's been talk along the lines, perhaps giving the AU a seat on the Security Council. That would help. But when Africa starts speaking from one voice, then I think a lot of the problems will start getting solved within Africa itself, which is why one of the reasons why we're having this discussion, because we know the resources are there within, apart from, when you look at Africans walking outside the continent, of course, reflective in this room as well, right from our vice chair and the council. So you look at Africans in diaspora. So, these are areas in which we can channel that in ensuring that Africa speaks with one voice. So whereby if there are things are going to be kind of taken to the ICC, you have the African Court of Human and People's Rights. You can enlarge the jurisdiction, because I know there's been talk about that, enlarge the jurisdiction of the African Court in Arusha to include crimes which fall under the Rome Statute, on which the ICC was created. And under the principle of complementarity of the Rome Statute, some of those cases can actually be held in domestic courts as well. As we've seen, remember when Hissène Barré left Chad, the long-time dictator in Chad, he was tried by a hybrid tribunal in Senegal. So it's possible. It's not that we can't do it. I mean, there's currently a hybrid tribunal in CAR. There was a hybrid tribunal in Sierra Leone, the one that tried Charles Taylor. So it can be done. So there's no reason why some of these cases we have to get the ICC coming in. If Africa agrees, we're speaking with one voice, we should be able to do this ourselves. Of course, with input from our colleagues outside the continent.
Let me say something on the issue. I think from a very practical perspective, we actually only have one House of Parliament. And that was a design, that was deliberately designed to be that way. No, it's true. What powers does the Senate have? The only powers that the Senate have is to pass something called the County Allocation of Revenue Bill. That bill arises from a formula that is passed by the CRA. So strictly speaking, all they do is allocate numbers to a formula. And this is not an accidental thing. I happened to be in the kitchen when the Katiba was being written. And there was our constitution is very majoritarian, you know. And so the majority communities were very concerned about the nature of the Senate, because the Senate is based on counties. The counties are not equal in population. So if you had given a lot of powers to the Senate, it would have marginalized the majority. That's how they felt. And so you notice that our Senate is therefore very deliberately very weak. All significant decisions, the most important decisions that the Parliament makes is the power of the purse. That power is exclusive to the National Assembly. You know, it is a power of making laws about how you distribute and how you set up institutions and how you allocate money to those institutions. Those powers are exclusively with the National Assembly. The Senate has had to go to the Supreme Court to get even the little powers that it has. So I think we need to disabuse ourselves of the notion that we have a two-chamber. We don't. We actually have one chamber and one that is there for show. Because actually the only power that the Senate has is to impeach governors. You know, and even that it doesn't do well. Thank you.
So was it a deliberate?
Yes, it was. That's what I'm telling you. It was majoritarian. The reason why even an institution like the CRA is very weak, it is because it is formed from the Senate. That system is majoritarian. It's supposed to protect the majorities.
As I go to Nancy, now that they have brought the point, why is it that then the Parliament chose, when you are amending the law, not Mr. Waiganjo, when you're amending the law in the Constitution, why did it make it very clear that in the first year you can impeach the governor, but if it comes to impeachment of a member of Parliament, you need 2 years? Was it an issue of accountability in terms of that Constitution?
You couldn't do it in the first 2 years, and you couldn't do it in the last year. That leaves you 2 years. Before you recall an MP, you must go to court and get an order that the MP has failed. Yeah. Number two, you must have, I think, was it what population of the voters? I think 20% or something, yes, to pass a resolution. And then you have to go through the motions. It was impossible. But when it comes to the governors, don't forget that members of Parliament are political competitors of the governors at home. So it is in their interest to weaken whoever it is who is the governor. You know, so in a sense, the process of impeachment of the governors is somebody. You know, in fact, it would be possible to impeach the governor, and there has been an attempt in their first 2 weeks, even before they have even appointed their personal assistant. So I'm saying that, again, in terms of the spirit of the Constitution, it was very progressive. You know, but in terms of its application, you have a whole, you know what they call law in the books, and what you find law on the streets, not even law in action. Those are two very different animals. And I think what you want to do as much as possible is keep reducing that gap. And some of that reduction has been done through the judicial process. Congress to institutions, I think Katiba has done 90% of the litigation that has helped reduce that as our country continues to move on.
Nancy, I want you to tell us, because in the UK, the world, there is this movement that is coming up on whether the House of Lords should remain the way it is or should be scrapped off. And as maybe because we're having the same discussion, as that's why I was juxtaposing him, in terms of the powers of the Senate and the Parliament. There is also another movement that is saying that the Senate here is the for retirees, people who are in retirement. That's why you see, when you lose the governor, you come using the Senate. And so in the UK, do we have there is this movement that is ongoing. And as the Bar Council, maybe in England and Wales, how are you being able, in terms of to come out with such, that's number one, with the way to reduce on them? And secondly, what is your take on this movement? Should it be scrapped off in terms of the rule of law? I know your area of practice is more of legislative and more. What is your take over all this?
Okay, so I can't comment on what the Bar Council's view is on this. I can definitely comment on what my view is and
yes,
what
view,
my
sorry.
understanding of the position is. So we do have a similar movement. So the House of Lords is, in its current form, unelected. It should be said, because Oladele gave you examples earlier, that it is robust, and there are many times that legislation has got through the House of Commons and got to the House of Lords, and the House of Lords has smacked it down or amended it to such an extent that the legislation no longer represents the form it was in when it arrived at the House of Lords. There is a movement to amend the House of Lords to make it an elected chamber. Because at the moment, what we're seeing, and I'm sorry, I realise I'm being very political in this discussion, but I think we operate in a very political climate at the moment in the UK, is that the Prime Minister can elect people to be members of the House of Lords. So there was controversy recently with Boris Johnson when he left, nominating members of the House of Lords. And one of the people he nominated, I think, was a woman who was under 30, was one of his private secretaries and had very little political and life experience. And that was very controversial in the media. So there is a move, all of that to say that there is a movement to abolish it in its current form, make it elected and more representative, so you have people that it can truly be said are deserving to be hold that great power that the House of Lords in its current form has. But as an institution, I would say that it does work, and I do think that for the most part, the people that are in the House of Lords take their responsibility very seriously. And you do have members of the church that are in there, retired members of the judiciary, as well as business members and other senior members of society. So it's not perfect. People are talking about changing it, but at the moment I would say it more or less is fit for purpose.
So do you think the change should be, and this one I want to hear your views, because some of us here, we are following that discussion and we're finding it. Do you think, are you for the scrapping it off or the empowering bit of it?
I am for, sorry, I didn't answer that question. Thank
Yes.
you. I am for the empowering bit of it, because I think the problem that you have in the House of Commons is because it's very politically focused. Governments who have a majority can get legislation through if they lean on their members to vote for it. And so you do need, I think the House of Lords has proved itself to be very effective at certain points in being a check on those pieces of legislation that have provisions in it that would violate human rights. I can't think of specific examples now, but I do know that there have been times where the House of Lords has basically said to the House of Commons, this is not going to fly, you need to come back with a better form of legislation. So I think in order for our system to work properly and not to clog the courts, because what would happen is if it goes through the legislature and it's a bad piece of legislation, it will ultimately be tested by lawyers. And so we don't really want to have lots of bad legislation going through and the justice system being clogged up because there's lots of test cases being brought against poorly drafted legislation that doesn't uphold the rule of law. So we do need a check. The House of Lords does work in providing that check, and I think it needs to be empowered so it becomes more of a democratic institution than it currently is.
In our BBI question, we tried to introduce what we call in courts, the chief whip of the judiciary. I wanted to hear from you, and of course our courts were very reluctant. Of course it was going to affect how they work, and it was one of the reasons as to why maybe BBI failed. We don't know whether by creating the appointing authority and vested in one person, especially the Prime Minister, do you think that one already compromises in how legislations are done and on how, because if scrutiny comes up, we go back to the master. Do you think there should be a way that it is left to be open so that then the Prime Minister does not appoint? Because you said she left and, he left and had appointed someone who was below 30. Do you think that that can be an amendment, or we should look at, objectively, we look at that situation and make, as you have suggested, for purposes of the future? Do you think that should be the position in the in your home area?
I'm not sure if I've understood the question, but I would say that I think I am for reform of the House of Lords. I am for it being a more democratic, an elected house. I mean, there are like pros and cons to that, because we see in the American system they have 2 houses that are elected and then they've got their problems. No system is perfect. But I think that, yes, there needs to be reform of the House of Lords. It needs to change, because the perception of the legal and justice system working is really important. And I think we are in a really difficult time at the moment in the UK, because I think of the pressures of people's living situations, cost of living crisis, increase a government that is taking action which people perceive not to be supporting them, that is causing people to question the political class and whether or not the political system is working for them. So the perception that we have fairly elected and chosen people that are doing the job that they are supposed to be doing is really important. And so that's why I'm pro-reform and pro making it more democratic. I hope that answers your question.
Yes, as we try to wind up, sir, then we can go to the plenary session. I would want, I think you have something?
Well, now just add to what Nancy said. I mean, the process as it is, even though it's not perfect, it's working to a certain extent. And I know during the Blair years and the Brown years, there was a move to open up membership of the House of Lords, where we had people's pairs, for instance, people could actually apply. And some people did get in that way. And when you look at even the House of Lords in its current composition, some of the most active working pairs, so to speak, are no longer the hereditary pairs. They're no longer those who are descendants of, quote and unquote, partners of a former monarch, or, But those are people, I mean, we look at people like Lord Panic, who's the leading silk, Baroness Helena Kennedy. Those are leading members of the bar, and they're active members of the House of Lords. So the system as it is could actually be reformed by having a, similar to how we have appoint judges in the UK, we have a judicial appointments commission. So appointments, instead of being made by the Prime Minister, we've got Liz Truss, for instance. She only was Prime Minister for just over a month, and she had a list as well. So we can have an independent system whereby members who are proposed to be members of the House of Lords are actually vetted and appointed by an independent appointments committee. So the system is there. So it really, that kind of system can work for that.
As your parting shot, maybe we would want to hear you as you conclude. We have summed up, and we understand maybe you have the conclusion, so then we can conclude. We allow the members to ask some few questions, and then I know if this discussion is to continue, we can even stay here for another day. I would want to hear from your parting shot. Okay.
Well, I think my parting shot is when I look at the legal landscape in Kenya and in England and Wales, we have a lot of emerging areas. Some of them have been spoken about earlier on. AI is an important aspect of it. Then the African Union does a lot of important work on, regulating data. There's an AU data framework. Of course, we've talked about after, even our meetings yesterday, after came up most times. So we're looking at, how that will also impact on provision of legal services. And of course, the independence of the judiciary and having a robust and sustainable independent legal profession, as well as a public who are actually aware of what their rights are. Public that is empowered, of course, the 40 states, civil society, and how those can build upon ensuring that they keep the government accountable, both the executive, the legislature, and of course the judiciary as well. So I think that's my part. But when I look at the future, I think the future is bright. So it's not something one has to kind of have this kind of fatalistic approach, but we have to be quite hopeful. You know, as Africans, we're usually very hopeful. And once there's life, there is hope. So, of course, I see that. And, of course, the future is indeed bright.
Thank you. Maybe, Nancy, as you say your the last remarks, there is one element in Kenya where we are having Articles 23, 24. We have so many people that are in these guys of those articles, and maybe Mr. Iganjo will also have the party. We have the Okiom data and others. People are filing public interest litigation, but in these guys of those public interest litigation, you find that they are pursuing private, of course, interests. How is it that in the area of practice and in Wales, how is it that it's done? Do we have also, I know there's what we call public defenders, all that, but here in Kenya, it's becoming a norm that everyone, he challenges this, this decision, you know. So is it there so that then you wind up, how has it been? How are you taking it? Is there any law that allows everyone, you know, every member of the public to challenge a decision? Because Kenya, before 2010, it was kind of limited. But now, by the virtue of that, Article 23 and 24, it was opened up. I don't know whether you have such provision that opens up.
What is Article 23 and 24?
Article 23 and 24 allows any member of the public to challenge any decision without you having an interest. You know, this is where they're saying action in rem, you have to have an interest in that matter. But here, if a road is passing here, any member, even if you are from Mombasa, you can challenge that decision. And they are coming under that article to challenge such decisions. I don't know whether in Wales and the UK there is such, because we are looking at access, the rule of law and access to justice, Kenya has opened.
So we, no, so we don't, this is my understanding, so I caveat that because I don't want someone more learned than me to say I've got it all wrong. But we do have restrictions on bringing litigation. First, there's time. So you have to bring your litigation within a certain period of time. We call that limitation. And depending on what type of area of law you're dealing with, you have a certain period of time from when the cause of action happened to bring your case. So I think with contract cases, for example, it's 6 years, but I'm sure the commercial barristers will tell me if I'm wrong. And with personal injury, I think it's 3 years from the date of the injury. In England, you generally need to have an interest in the claim. I think what we are seeing more of an increasing trend in is publicly funded claims, because sometimes people that have an interest don't have the means to hire lawyers. So there's tools being used such as crowdfunding to get cases to court, and those cases can be funded by members of the public that have an interest in having that particular issue scrutinised by the court, but the person that brings the claim must have some sort of interest in the issue that's before the court.
Thank you. In your parting shot?
In my parting shot, yes, yes. I think the same as Oladele, I think hopeful. So I think that the rule of law is one of those principles that everybody talks about, but very few people understand. But we know it's something very good and something that we need for our society to function properly. I think that in every society has its own challenges in terms of respecting the rule of law, because we operate in a climate where people have their own interests and there are significant imbalances and inequalities. It's easier for a rich person to have access to justice than a poorer person to have access to justice, for example. But I think that in all countries that I have experience of, so in Sierra Leone, here, from my understanding of what's happening, and in the UK, lawyers are playing a really important role in ensuring that there is access to justice and the rule of law is being upheld. And I hope that work continues.
Thank you.
I'll just add, it's not, I know I've done my passing shot. Just to echo what Nancy said earlier on, even though we don't have the equivalent, I think it's Article 23, yeah. But litigants have been very creative in the last couple of years in the UK. You have, there's a good law project which is led by one of the leading silks, his name escapes me now. Yes, they brought in a lot of cases, particularly with the COVID contracts, Boris Johnson. And when we talk about corruption, I mean, you might then argue, well, is there an issue of corruption in the UK? There was also, if you remember, we've talked about the Brexit cases as well. Yes. That was brought by private litigants. She actually started the case. There was a Scottish MP who started the case in Scotland, and then the case was then joined in England and Wales. So there have been creative ways, and then we have the Freedom of Information Act, which allows members of the public to hold public institutions to account. So in this kind of creative way, some issues have related to the Freedom of Information Act as well. So, I mean, even though we don't have those specific provisions, but there are other provisions within the law which allow litigants to bring causes of action in court, which strategic litigation has been happening.
In Kenya, we have people, there is one of Okiya Mtata and one of our own who litigates, and he's in this room. When we're here, he will tell you how to navigate about it. I don't want to mention the name. Mr. Kamara.
Yeah, I think Coin, you even have to start with Article 1 on the sovereignty of the people and how the people decide to exercise their sovereignty. Sometimes it's through public interest litigation, and I think for me, you need to expand that territory as much as possible. I think it's important that Kenyans own the constitution, and it is not the preserve of lawyers, and and so I like it that Mtata is not an advocate, and it's important that many of those, not the ones who pretend to be advocates, but those who are just citizens litigating on public interest issues. So that is a space actually we should be encouraging to be expanded. I think when it comes to people misusing, the courts have the tools to deal with it, even through costs, even sometimes imposing costs on lawyers who are abusing the process. But I think as much as possible, let us expand that space so that the constitution settles in the psyche of the people. In terms of, I think, my parting shot, two comments. I'm an eternal optimist. I think I lived in the days when we would not have had this meeting without expecting the police waiting outside here, and when as a student in the law school, we were the late Okiya Mbaka's interns, and he was involved in an inquest, and the police came to the school of law. We were just students, and we were just participating, taking notes. So I have lived in that time. So I am an eternal optimist. I know we have, but we still have so much to go, and we need to demand a lot more of ourselves, and not compare ourselves with Somalia, but to compare ourselves with the best. But I think my final point is that all these conversations are all very well in the Kempinski, but I think we need to understand that the rule of law has very little meaning to people who are struggling at a very basic level. And I think the conversations, even as we push the rule of law, we must also, even as lawyers, keep asking the questions about how do we empower people so that they truly can support the rule of law. And they're not going to do that if they're desperate. Now, as to what that looks like, I don't know. But I'm just saying that we need to be careful not to have very nice, sanitized conversations that actually have very little meaning to 80, 70% of the population. And we need, as a legal community, to be asking that question at every time. What is it that we need to do so that we don't have a desperate citizenry which can then be exploited and for whom the rule of law means nothing? Thank you.
Thank you. Members, I think we can clap for our... I'm sure for those who are in the room, you have learned a lot, but we are yet now to go to the plenary side, then we can be able to... I'm sure what Mr. Iganjo has said, if you ask someone who is in Mavoko, he doesn't understand that there is a rule of law when he carries the title. I will take, I'm being told it's minutes, but we shall see. Even court, you allow extension of time. I will begin. I know the side that has a lot of questions, but everyone, I think we can take the first session We first take 2-2 from this row. Let's be orderly from this row. If there's any question or something to clarify, especially from our brothers from the UK and Wales.
Hi. Could I ask Mr. Waiganju?
Yes.
Oh, sorry, David Simpson. I'm a barrister in London. You mentioned, you spoke of the decision of the Supreme Court to overturn the election here as a kind of practical defeat because it resulted in the weakening of the judiciary. I've always thought that was an immensely courageous decision that had been made by people who are standing up for possibly the biggest decision of their lives to uphold values. And I think if you want to test case what happens if you go the other way, look at what happened in Uganda, where the Supreme Court upheld one of the most corrupt elections that had ever taken place in that country. And Kizza Besigye wasn't even allowed to contest the election, to contest the court hearing because he was under arrest. Is your thesis that actually that decision was a good decision because it resulted in the institution of the judiciary coming under less attack afterwards, and therefore the rule of law in Uganda remaining strong? Is that the kind of logical conclusion of that argument?
Thank you. Another questions, and then they will answer them at this side. Okay. There, someone.
My name is Abu Bakar. I'm an advocate of the High Court of Kenya. My question goes to Nancy. I would like you to shed light on the agreement between the United Kingdom and the government of Rwanda regarding the settlement of refugees and asylum seekers and the impact that has had on the rule of law and the rights of refugees in the United Kingdom.
My name is Stephen Musile. My question goes to also Mr. Ganjo. I'm actually a very keen student of the rule of law and the governance. The Constitution of Kenya 2010 is said to be one of the most progressive constitution, actually, more so if not in Africa, also in the world. But we have actually said we have had a problem, which for me it sounds like we have had a very overambitious constitution, whose implementation is actually to our disadvantage to some extent, has got so many disadvantages as compared to the advantages. We have actually also seen this one also practically, agreeing with you that some of the decisions that have been made by the courts against the executive and also the parliament have had a very bad negative implication on the judiciary, and sometimes to the individual judges. Is it time that now we go back to the drawing board and we amend this constitution and we make it compliant to our environment, or we just leave it to have just aspirational provisions which cannot bite because we are afraid of the consequences? Thank you.
I was expecting.
Hello, my question goes to Abli Mutunga, and my question goes to Mr. Oladele. The first question is, how does the judiciary in UK ensure that its decisions are complied with or respected by the government? Hypothetically, what would happen if the government refused to obey an order of the court in the UK? And then my second question more touches on housing laws, because you mentioned you work for the council. Yeah? So I'll give you an example. I have a friend who is earning hourly wages in the UK. So he cannot afford a solicitor or barrister. I did not pretend like I was going to advise him, but I just told him, have a look at this. I'll go to Citizens Advice. But what I found intriguing, I found that the laws in the UK are more favorable towards the tenant as opposed to the landlords. And an example, we have an existing statute here in Kenya, I think it's the Landlord Tenant Act, where we cannot terminate commercial leases in this country, and I think we borrowed it from the UK. And what's your view on that? The rule of law says it's supposed to be equal to all people and institutions. However, you find that there are times where you find that laws, for example, in the context of landlords and tenants, lean more towards one party at the detriment of the other. Thank you.
There is still some hand.
Good afternoon. My name is Francis Wanjiku. I'm also an advocate. Formerly, I was at the Commonwealth Secretariat as a young professional. My question, I have two questions. So one of the questions is, when it comes to government policy as opposed to judicial decisions, where should the judiciary draw the line? And a good example my friend Abu Bakar has just given is the decision by the UK government to take people or immigrants to Rwanda. When does the judiciary say this is a government policy, we should not interfere as a government policy? Here back in Kenya, we have recently a policy by the government that tells people you can cut trees now in public forest. So should the judiciary be saying that we can interfere with a government policy such as that? My second question is on the fact of constitutional values. I know the UK does not have a written constitution, but being a researcher, I've realized that in our constitutional courts, I rarely see our courts taking cover over UK precedents when it comes to constitutional values. Does it mean that the UK does not have real constitutional values? Or does it mean that it's the UK which should now be borrowing from countries like Kenya when it comes to implementing constitutional values? This question is quite emotive because I've gone to places like Zimbabwe. I've not gone to Samoa, but I know that Samoa are currently, even people in the Pacific are currently borrowing decisions from Kenya when it comes to what Mr. Waiganjo talked about in terms of election petitions. When a judge says, I'm nullifying an election, what does it mean for other people, especially within the Commonwealth? Thank you.
Mr. Daldrocher. Oh, thank you. Yes, I think let me begin with Mr. Waiganjo. And
thank you so much. The first question was about is the natural progression of my decision, of my position that would rather go the Uganda way. I think let me make it very clear that there are very many positives about the 2017 decision. Just so that one, I started by saying it was very jurisprudentially sound. It established very important principles about how you assess the validity of an election beyond the numbers. It was also good in terms of politically, it said to the world that Kenya can survive. It can survive the nullification of an election. Countries go down because of something like that. It also said that the presidency can be challenged, which was good for the national psyche. So I don't think it's all lost. But I do think that on matters like that, and especially where the election itself is a very close election. So this election could have gone either way. I'm not even sure that even the court imagined that in a by-election, the results would necessarily be different. So in that sort of situation, then you need to be pragmatic in the way you make the decision. Now, the difference between Kenya and Uganda is that, remember that in Kenya, the rules, the constitutional foundation was in existence to protect the judiciary. It had started to grow. In a sense, the judiciary as an institution was ready to start to find its foundation. So this was a time in its infancy, but the rules are there to protect it. It is not where, like in our neighbors, in my brothers, where the president runs the show, in every respect, and appoints judges and can fire them, even if not directly. Here, that power has been taken away. So the institution, in a sense, had the roots within which to grow, but it was still very young. So this was not the time, in my view, in my honest view, this was not the time to challenge the executive in a frontal manner like that. I think there are other ways that the judiciary could have gotten to that, including giving interdicts that will then manage the next election. To be able to say in the next election, the IBC must be able to do this, and he must be able to report to the Supreme Court, you know, so that in a sense you manage the next election, and you buy it without in a way endangering the institution. And I say this honestly, even though I have a lot of respect, and I think it was very courageous. I think it took a lot of guts to get to, but I'm not sure that in terms of wisdom, in my own view, that it was tempered with sufficient wisdom, in my own view. And these are colleagues who we have a lot of respect for, and we've had these discussions even informally. So that's I think one has to look at context. Abu Bakr, I think, what was your question about? I wrote, sometimes I can't read my handwriting, but I'll get to Musili first, the keen student of the rule of law. I don't believe that you have a problem with the Constitution. I am not one of those people who think that the Constitution is a problem that needs to be managed. I do think that the intentions of the Constitution should be met. The question is, how do we get there? So my problem is not to go backwards. And I think the country, the executive needs to be challenged. I think the word used is being beaten. The executive needs to be beaten. Beaten, B-I-T-T-E-N, that one. It needs by the courts. I think the only question is, how do you do it when you're a young democracy with young institutions in the context of a transition? No, because the clamor to amend the Constitution actually comes from the danger that the Constitution poses. And the Constitution is not a danger to the people. The Constitution is a danger to those in power. So when we say let's amend the Constitution, for the benefit of who? Because it is not for the benefit of the people. I do not know a single provision in the Constitution that people should amend because it's anti-people. It's always anti those in power. But I do say that you require pragmatism. Then my final point is on policy. I think it's Wanjiku who raised, that's the owners of the Constitution. You've always wondered, Wanjiku. There he is. Now, I think that government policy is not the end. I think government policy must also be tested against direct constitutional provisions. For example, human rights. You know, I mean, government cannot make policy that abuses people's rights. Government cannot make law, cannot make policy that abuses environmental law and precise environmental provisions and safeguards that are there in the Constitution. So yes, there are certain areas in which government has significant discretion on policy. But that policy must be tested against constitutional safeguards. And if that is not done, then it means that the Constitution has no teeth against the executive. So I would say, yes, there's a place to test, but it should only be tested against constitutional values. Not just that the courts have a different opinion on policy, but that the Constitution and our constitutional values direct the policy to be moved in a certain direction.
Okay.
So I think what I'll do is I'll deal with the Rwanda questions together because I think they're linked. So in terms of the Rwanda issue, what I will say, I haven't read the judgment. So qualification, I haven't read the judgment. I've read reports in the news about the judgment. And my understanding is that the lawyers have been very careful about how they're testing this government policy. So the question, as I understand it, that was before the court was not whether or not the policy was right or wrong. It was, is Rwanda a safe place for asylum seekers to be sent to whilst their applications are being processed? So in terms of the question that was asked about, does the judiciary test or interfere with government policy, as I understood it? In the UK, the judiciary and lawyers are very mindful that they shouldn't be trespassing on making decisions for governments or saying outright that a decision is right or wrong. What they will do is test it within the parameters of the legal framework. And so that's how they've structured the question around the Rwanda issue. So it's not, this is an unlawful policy, it's, does this policy actually work, and does it respect the values of human rights which we hold dear in the UK? In terms of what the position is, I wouldn't say it's a fight between the UK and the government of Rwanda. I would say it's actually a fight between, if you were going to call it a fight in stark terms, the lawyers of the UK and the government of UK and Rwanda. Because what the lawyers in the UK are saying is that question, they're posing that question. And as I understand it, it's gone up to the Court of Appeal now. So in the High Court, they found in favour of the lawyers. So they said, actually, we can't be sure that Rwanda is a safe country for asylum seekers. In the Court of Appeal, they took a different position. And so what I think that demonstrates is how alive the rule of law is in the UK. Much to the dismay of the government, because the government are very upset that lawyers have had the audacity to challenge this policy, which is a very populist policy. I would say most members of the UK society do not like asylum seekers or immigrants, and they would prefer that we limited the numbers. So it shows that lawyers in the UK are not afraid to test the law or legal policies, that judges can differ in approaches, because we've had two different judicial tribunals taking different approaches to the same question. And so I say that shows that the rule of law works. So I think that answers the questions about that issue. In terms of the constitution question, I don't think the UK constitution needs to change. I think the UK is very proud of the fact that it has an unwritten constitution. And I think that the judicial arm of our constitutional framework, which gives life to legislation, does draw upon different legal values and principles in other countries. So often when you read judgments, particularly in the higher courts, you will see them refer to principles in the UN Bill of Human Rights or UN documentation. They may look at different jurisdictions that are similar to us. The most pertinent example that I can think of is Canada. And so we are, when they're making their, what I'm trying to say by that is when they are making their decisions, they are influenced or mindful was probably the best word to say, of other jurisdictions, other ways in which other judges are dealing with the same questions. And so that does filter in some way in the decision making and does influence that form, that arm of our constitution. So I don't think it should change, but there is a mechanism for our constitution to be mindful of what other jurisdictions are doing.
And I think to answer the question, I know I have a number of questions. There's a housing question and also how the judiciary gets the government to comply with court orders. But I would piggyback on what Nancy said about our constitutional values in the UK. In as much as we don't have a written constitution per se in the UK, we have various acts of parliament down the years which actually form the basis of constitutional law in the UK as it is. For instance, you can go back as far as the Act of Union with Scotland. I know Phil will be interested in that. And that's a core constitutional principle, and even going back as far as Magna Carta. And then you have, even the Brexit cases as well. So there's case law as well. So there is a rich tradition of, laws, cases which are constitutional in nature, and on which the UK draws its constitutional experience. So we might not have a basic law contained in one document, but we have a series of laws which counts as the unwritten constitution of the United Kingdom. Now, to address the substantive questions, how does the government, how does judiciary get the government to comply with court orders? I mean, that's simple. Even lawyers, government lawyers, know they have to. My role, for instance, when I work for the local authority, I advise the local authority. I tell them. We were talking. Barbara talked earlier on about gatekeeping. We're not gatekeepers. I advise the local authority, even though I work for the local authority. I advise them that this is what you should comply with. If you don't comply with that, these are the consequences. For local authorities, it's believed it's very punitive in the UK. Councillors, for instance, have a financial responsibility. We've had a number of local authorities who have been insolvent in the UK last couple of months. Those councillors who've made that decision will be financially responsible for those decisions they've made. And there have been cases in the past. There was a popular case in Westminster where the lady went to Israel because she was a joint citizen. She has joint citizenship with Israel. It's a famous case. Everybody can, I don't want to name names. She went to Israel and there was a surcharge against her. Of course, she was the heiress of Tesco, which is one of the biggest supermarkets. So they were able to get the money for which Westminster was indebted to then from her because she was a councillor. So there are different mechanisms and of course costs. I'm also mention issue of cost as well. So, I mean, I've been, even when I was in the CPS, for instance, we get court orders where the judge will say, I want the head of the trial unit to appear in court and show cause as to why we should not impose costs against the CPS. That's happened. So, officers, public officers know they could be held to contempt. I mean, even the Secretary of State have been held to contempt of court. So that's one way in which the court holds the government to account. And that's a key plank of rule of law. The second question is the housing laws are favorable to tenants. I think there's a history behind that. I recall, the years, many years ago, there was a famous thing where you had the law of the Windrush generation, of which my parents were, and of course those of us who have Caribbean and African extraction who were in the UK then. Of course, I was born towards the tail end of that. I don't want to show my age now. There was, the popular sign that was put up was no Irish, no blacks, no dogs. So landlords, there was a time when the law was much more favorable to landlords. But over the years, that has changed. We have a Prevention of Eviction Act, 1976 Act, which allows a tenant to take action. It's actually a criminal offense. If a landlord evicts a tenant without going through the normal process, the landlord could actually be found guilty in court and be either fined or given a custodial sentence. So it's over the years that has changed, and that is why there's been the law. The way the law is much more favorable to tenants. But if you're a landlord, by accident, I'm a landlord because, I don't want to go into history of that. If I do anything that is wrong, I could be held liable both by the courts, and of course, I don't want to come before the Bar Standards Board for breaching my duties as a landlord because I have to register with my local council as a landlord. So there's a lot of checks that have been put in place because we had, and now we even have a register of rogue landlords. So that is why tenants are protected. And remember, tenants are vulnerable. Most tenants, you might have commercial tenants who can instruct, my colleagues like Simon and David, they're commercial barristers, they charge high fees, so they can instruct them. But most tenants are not, they're not of that disposition, they're not of means. So that is why the law seems favorable to, but if you're a landlord and you're responsible and doing the right thing, you'll be able to, if a tenant is owing you money or has not followed due process or has breached their tenancy conditions, you're able to evict them. So, that's to address that. Then, in terms of government policy and where does the judiciary draw the line, I think we've dealt with some of those issues. We look at the Human Rights Act, Section 6 of the Human Rights Act allows the court to hold public authorities accountable where they're in breach of the convention rights of an individual who brings a case against that public authority in court. And I think that's kind of a whistle-stop of all the questions that were asked. I hope I've addressed all those salient points within the questions that was asked. Thank you.
Thank you. I think we're almost coming to an end. Though you touched on, my colleagues touched about Uganda, and that's where I come from. But I want to tell you that the electoral laws are also like the ones in Kenya. The only challenge that we have is that our electoral laws have three issues. One, we have not grown to reach to an extent of electronic voting. Secondly, in terms of when the votes are being counted and when the announcements is being done, if you are to challenge the election results, the president has to be first sworn in. So the president is sworn in, then you can challenge. Other than Kenya, where now we wait, there is that, all that. In Uganda, what we only did was just to help in terms of streamlining. Here you wait for long. And us, we provide for 3 days. The results have to be announced in Uganda. In Kenya, they have to wait. All of them, and even everyone, didn't know who the president is. But what I can tell you, through the electoral process also, people have challenged, including Bob Wine, Amama Mbabazi, VSJ challenged. The only challenge that we had with VSJ is that the court found that there were irregularities, but those irregularities were not enough to nullify an election. Up to now, there are people who have reservation. When I was doing law, we used to have reservation over that judgment, but I've read it and analyzed why they did that. That's why Waiganjo said that in 2017, they ought to have done the wisdom. And that's why Uganda did that in 2006, the wisdom. So that was a good wisdom. In last year, but one brought evidence and all that. He had some evidence, but we have to give it to the courts. Because when the president extended, when the parliament amended the constitution to include that you remove the term limits, you remove the age limit, then now, because of that, the members of parliament came and said they also want to expand from 5 years to 7 years. The court said no. So we are doing well. So, and with that, I think if we are to remain here with the rule of law, we can have a discussion, and that's why the judgment and the decision of handing over immigrants from UK, that agreement as a government policy, some of us, we have issues about it, because it defeats the freedom of those immigrants, because you don't have a choice to be an immigrant, and you can be taken somewhere. You remember when Kenya decided that Dadaab and all that be closed, you saw how all international bodies were all over up in the arms. But when they said that immigrants can be taken to Rwanda and all that, the fortunate part with that is that Rwanda can use it because there are no safeguard. And when you read the Court of Appeal decision on that issue, if you're taking an immigrant to a foreign country, there should be the consent of that person. That's number one. Because otherwise, what safeguard will you put for people who ran away from Rwanda and now are being brought in disguise of immigrants and are being charged in Rwanda? As a matter of rule of law, the rule of law has its own sides. It has its own positive, negatives. But at a personal level and at our panelists today, we have tried. It does not mean we have finalized. We shall have another discussion in the near future and the events from now, where now I say thank you, everyone. I have seen senior council. We recognize you to be with us. I've seen council member Harriet Mboche and others. I saw Maria Mbeneka and others and everyone. We thank you. Here now, I think we can clap for our discussants. They have done a good job. And I'll now call our able, now they can be escorted to have a seat. My role and my duty, I think now it has come to an end. Now I call our Deputy CEO, Mercy, Mary, to take us to another session. But I say, today has been also another special day for me. But I wish you well. Thank you very much.
It's Koyan's birthday. That's why he's very excited today. Thank you so much, everyone. We've come to the end of our program. I'm sure most of us are thirsty, myself included, for water, but we'll have the drinks reception as on the program. But let me just give 1 minute to Barbara Mills, KC, to just give a vote of thanks from their side. For our members, just to hear that they're grateful for them.
Thanks again, Law Society of Kenya, for inviting us. What a vibrant and interesting day we've had. I haven't stopped making notes, so thank you very much. We're very pleased to be associated with you, not only as siblings of the family, which is the Commonwealth of Nations, but also because of the opportunities that we rightly recognize here. Your strong and sophisticated dispute resolution structures, including the Nairobi Centre for International Arbitration, the developing financial court in Nairobi Financial Centre, our shared common law systems, and our shared values. Also the pre-existing relationships between our two governments. Listening to the delegates here today, there are differences between us for sure, but so many similarities. The threat to the rule of law, the separation of powers, the accountability of government, the threats to the judiciary, the fear that some of us have of AI without realizing that actually it's all around us, and I was happy to hear about the narrow AI, the regulation, the importance of independence, and in particular in a time where arbitration is ever growing, to understand that it's really a part of, and necessarily so, the whole family of dispute resolution. So mediation's in there, litigation's in there, and arbitration is in there. And never forgetting the importance of the supervisory role of the court to make it robust and sustainable. The law that we all care about is increasingly global, and it is great for lawyers to meet in this way, share knowledge, exchange ideas. It's the only way, in my view, for us to understand and become aware of new theories, processes, and procedures as we emerge from and improve our legal services. So on behalf of the delegation from England and Wales, Simon, Dele, Hamad, David, Nancy, and Amrit online, who are the lawyers, and Phil and Militia, who have put it all together, we thank you greatly for the invitation to attend and collaborate with you on this day of legal training. You rightly recognise the need to partner with various stakeholders in order to facilitate the joint missions of better understanding of what lawyers can do and promoting the rule of law. There's an African proverb which says, if you want to go fast, go it alone. If you want to go far, go together. I'm very pleased to go together with you. Thank you.
Thank you, Barbara. We'll have a drinks reception somewhere on the first floor, but the waiters are just on the corridor to direct you. That's it for us. The Law Society thanks you so much for attending this forum. We are happy that members were engaged throughout the day, and we look forward to future collaborations. Thank you to our speakers. Thank you to Senior Counsel for attending and being with us throughout the day. Thank you, Council members and colleagues. And I think we can close with a word of prayer from a volunteer. Please, someone volunteer, please. We need a volunteer for this. Thank you, Wendy.
So let's pray. We come before you, dear God in heaven. We thank you for what we've had today, for the gift of life. Whatever we've deliberated today, may it be with us. We may not be able to do this through our own strength, but we believe that even as we leave this room, more collaborations will come through, and more implementation of our ideas will also be done. We pray this trusting and believing in Jesus' name. Amen.